Welcome to everyone who is joining us. The weather here in Syracuse is getting a little bit better, seems to be turning. Everyone's in a little bit better of a mood. So we hope you enjoy the presentation that we have for you today. It is packed once again. We're going to start off with some recent developments in the world of the EEOC, which is the Equal Employment Opportunity Commission, and its guidance on how you as employers should deal with requests for religious accommodations in the context of vaccine mandates. And to talk to us about that topic is Brittany Frank. Brittany is an attorney in our Garden City office. Brittany, take it away.
Hi, thank you for the introduction. My name is Brittany, as Adam said, and I'm talking about the EEOC updated guidance on objections to COVID-19 vaccine mandates. So on March 1st, 2022, the EEOC updated its guidance on religious accommodations to COVID-19 vaccine mandates. Job applicants and employees have a right to request a religious accommodation to an employer's COVID-19 vaccination requirement. Employees must inform their employer of their request for a religious accommodation. But note that in making this request, the employee does not need to use any magic words such as Title VII or religious accommodation. They simply need to state the religious basis for their objection. Employers should provide information on how to make a request, such as who the employee should contact. And in the guidance, the EEOC included a link to its own internal workplace form, which employees can use to make such a religious request. In evaluating an employee's request, the employer may make a limited factual inquiry and seek additional supporting information if there is an objective basis for questioning the religious nature or the sincerity of the employee's belief. And if the employee does not comply with this request, they risk losing a claim that their request was improperly denied. The EEOC guidance specifically states that Title VII does not protect social, political, or economic views or personal preferences or other non-religious concerns. So an example of a non-religious concern would be the concern about the possible effects of the vaccine. Note that there could be overlap between a religious and a non-religious belief, and that such belief might still be protected if there is a religious basis for it. So the EEOC also listed factors that may indicate that a belief is not sincerely held. These factors are whether an employee has acted in a manner inconsistent with the possessed belief, whether the accommodation sought is a particularly desirable benefit that is likely to be sought for non-religious reasons, whether the timing of the request renders it suspect. For example, if it follows an earlier request by the employee for the same benefit for a secular reason, whether the employee has another reason to believe the accommodation is not sought for religious reasons. Note that none of these factors are determinative, and the employer should evaluate on a case-by-case basis. An employer may deny a request for a religious accommodation when it would pose an undue hardship on the employer. Before denying a request, the employer may want to consider accommodations such as remote work or reassignment. Some of the costs to consider are whether the accommodation would burden the conduct of the business, and the guidance states that this includes the risk of spreading COVID-19 to other employees or to the public. Other costs are monetary costs, anything more than a minimal cost, whether the accommodation would violate federal law, whether the accommodation would impair workplace safety, and whether the accommodation would diminish efficiency in other jobs, or whether the accommodation would cause coworkers to carry the accommodated employee's share of hazardous or burdensome work. There are some considerations that are specific to the COVID-19 pandemic, such as whether the employee works outdoors or indoors, whether the employee works in a solitary or group setting, whether the employee has close contact with other employees or members of the public, especially medically vulnerable individuals, and whether many employees are seeking a similar accommodation. Some other notes that were in the EEOC guidance that I think are significant is that an employer does not have to grant all requests, even if it grants one request, whether the religious belief is sincerely held and whether the accommodation would constitute an undue hardship on the employer should be analyzed on a case-by-case basis. So clearly, in granting one request, it doesn't necessarily mean that the same analysis would apply to all requests. An employer does not have to grant an employee's preferred accommodation if another accommodation is available and reasonable. An employer who grants a request for an accommodation may later reevaluate the request based on a change in circumstances. So, for example, an employer may discontinue a previously provided accommodation that later poses an undue hardship on the employer's operations due to a change in circumstances. That's all. So thank you so much.
Brittany, thank you. That was incredibly helpful. I have a couple of follow-up points. First of all, someone in the Q&A mentioned this, and I think it's worth pointing out. The rule in New York State for healthcare employers, hospitals, nursing homes, is going to be different because it does not allow for religious accommodations to the specific vaccine requirement in those settings. So that's one thing. The other is, if you remember, and you've been with us for the last 2 years on these webinars, we've talked quite a bit about vaccine mandates. And in implementing a vaccine mandate, you typically want to have three things. You want to have a policy document that lays out what your vaccine mandate is, your policy is. You want to have a religious accommodation request form, and you want to have a medical accommodation request form. Those three things really help you implement and administer a vaccine mandate in an appropriate way. This new guidance that the EEOC came out with helps you, when you receive one of those religious accommodation requests, helps you process it and make a decision about whether or not you're going to grant that accommodation. So all those things that Brittany talked about are relevant if you have a vaccine mandate and you're getting those religious accommodation requests, which I know a lot of clients are. I've been dealing with one just recently in the last couple of days. So thanks, Brittany. Very helpful. We really appreciate it. Okay, next up, Aaron Pierce. Aaron is a member in our Syracuse office. Aaron deals specifically with employee benefits, and he's going to talk to us about some retirement plan amendment deadlines. So Aaron, the floor is yours.
Great. Thanks, Adam. And hello, everybody. Again, my name is Aaron Pierce. I practice in Bond's Employee Benefits and Executive Compensation Practice Group. Wanted to take just a couple of minutes today to remind folks of some upcoming retirement plan amendment deadlines in 2022. Obviously the last couple of years have been a whirlwind of new compliance obligations, new challenges for employers to comply with in HR, in the HR field and otherwise. But we can't forget that we continue to have employee benefit deadlines that creep up on us, and wanted to get in front of you relatively early in 2022 and remind you of a couple of deadlines that are coming up this year relative to retirement plan document amendment requirements. The first is COVID related, and that's what we refer to as the CARES Act amendment. So if you recall, back in early parts of pandemic, Congress adopted a huge package of relief called the CARES Act that included a number of benefit plans changes. amendment to implement those changes or to reflect the changes that an employer may have implemented with its retirement plan, and we'll talk about what some of those are in a minute, is for a calendar year plan, December 31st, 2022. So if your plan operates on a calendar year plan year and you implemented one of these retirement plan CARES Act changes, you want to make sure you have a retirement plan amendment in place and adopted no later than the end of 2022. Governmental plans in certain circumstances get an additional 2 years out into 2024, but for the bulk of plans who operate on a calendar year plan year, the deadline is December 31st of 2022. The same is true for the Secure Act. The Secure Act, which predated the CARES Act by a few months, made a number of other relatively significant changes to retirement plans, and all plans are required to be amended to reflect those changes by the end of 2022, or for a governmental plan by the end of 2024. The last set of deadlines that we'll talk about, and I'll give you some details in a few minutes, it applies only to what we call pre-approved defined contribution plans. So these are 401k plans, profit sharing plans, employee stock ownership plans that utilize a plan document that has been pre-approved by the IRS as complying with all the various qualification requirements that apply to such plans. That deadline is coming up earlier. That is a July 31st, 2022 deadline. And I'll give you some more details about who has to worry about that and what you should be doing to make sure you meet that deadline. So if we move on to the CARES Act, I'm just going to give you a couple of highlights just to remind people of what the CARES Act did and whether or not this is an amendment that you need to make sure you take care of in 2022 to be in compliance. So the CARES Act did three primary things with respect to retirement plans, and they were all aimed at giving relief to participants who may have been adversely affected by the COVID-19 pandemic. The first change was allowing, not requiring, but allowing retirement plans to give access to account balances by people adversely affected by the COVID-19 pandemic. This is what's referred to as the coronavirus related distributions. A plan could permit a participant affected by the pandemic to elect a distribution of up to $100,000 in service, so they don't have to terminate employment to get it, to allow, obviously to help them with any financial burden that may have occurred as a result of being affected by the pandemic. A similar set of rules allowed greater access to participant loans. So a plan could have been amended to increase the limit on participant loans, which is normally $50,000 to $100,000. It also included provisions that allowed for suspensions or extensions of repayments on existing loan obligations. Both of those changes were completely optional. So an employer was not required to offer these options to participants. But if a plan did offer those options to participants, an amendment to reflect that has to be adopted by December 31st of 2022. The last change that would have to be reflected in an amendment this year, is the waiver of the 2020 required minimum distribution rule. This is a rule that normally would require, if you're a terminated employee and you've hit the required beginning date, which used to be 70 and a half, now is 72, you were required to take a distribution of at least some of your account balance on April 1st of 2020. That was waived for 2020, again, if the plan chose to waive it. So you need to make sure that if you implemented any of these changes to your retirement plan, that you adopt an amendment by no later than December 31st of this year to reflect those changes. If you did not adopt any of these changes, then no amendment is required, at least from the perspective of the IRS. So the IRS wouldn't say you'd have to adopt an amendment, but be careful. Some providers out there are still requiring employers to adopt a CARES Act amendment, even if they did not implement these changes. Essentially, for an employer that chose not to implement that changes, what that amendment would simply look like is to say, hey, the Congress made these options available, but we as an employer decided not to make them available under our plan. Some providers want that documentation. So check with your provider, see if this applies to you, and make sure you've got a process in place to get that amendment adopted by December 31st of this year. Now we switch to the Secures Act on the next slide. Secures Act did a number of things. I'm not going to talk about all of them. I just want to hit a couple of the highlights. The most important of which is the change in the required beginning date from 70.5 to 72. So again, this is the date by which the IRS tells plan participants, if you've terminated employment and you hit this age, you have to start drawing your benefit from the plan. It used to be 70.5. They bumped it up a year and a half to age 72. All plans are required to be amended to reflect that change. So everybody's going to have to adopt an amendment to reflect the change in the required beginning date from 70.5 to 72. The second mandatory change that's in the Secure Act applies only to 401k plans. And this is a new rule that says, if you offer a 401k plan, you have to make the ability to make elective deferrals under that plan available to long-term part-time employees. And what a long-term part-time employee is an employee who worked at least 500 hours or more in 3 consecutive years. So under old, you may have excluded these employees in the past because they did not meet the plan's year of service requirement. It's common for a plan to say that you've got to work 1,000 hours in a year to become eligible to participate in the 401k plan. This is an exception to that rule. And if you have an employee that averages 50 or more hours a week, or excuse me, works 50 or more hours a year in 3 consecutive plan years, you have to offer them the ability to make elective contributions to your 401k plan. So you need to start tracking those hours and making sure we know what employees we may need to offer the ability to make contributions. Couple of notes there. This is just elective contributions to a 401k plan. Does not require an employer to make matching contributions available. Does not require an employer to make employer contributions available. But if they work 500 hours or more in 3 consecutive plan years, the plan would need to offer them the opportunity to make contributions to a 401k plan. Again, that's a mandatory change. So a couple of other optional changes. One is the qualified birth and adoption distributions. Plans can, if they so choose, allow participants to elect a up to $5,000 in-service distribution from the plan to help pay for birth or adoption expenses. Again, not required, but is an option a plan could choose to permit. And then we also have a new rule that allows in-service distributions from defined benefit pension plans and money purchase pension plans as early as age 59.5. So all plans will need to be amended by the end of 2022 to reflect at least the mandatory changes under the Secure Act and also to reflect any of the optional changes that they choose to implement. And then the last amendment deadline you need to be aware of pertains only to defined contribution plans that are maintained in the form of a pre-approved specimen plan. So it's very common in the 401k and defined contribution plan rules to utilize a provider's pre-approved document. What that means is the provider drafted a template document, they submitted it to the IRS took a look at it and issued a ruling that that document met all of the qualification requirements under the Internal Revenue Code in form. So an employer could then adopt that document and rely upon the IRS's ruling that that plan document met the applicable qualification requirements in form. If you use a pre-approved document, that document has to be updated and amended at least every 6 years. And defined benefit plans and defined contribution plans operate on different 6-year cycles. Last year was the 6-year cycle ended for defined benefit plans. This year, the cycle ends for defined contribution plans. So if you utilize a pre-approved document for your defined contribution plan, that document's going to need to be restated and executed by no later than July 31st of this year, July 31st of 2022. In addition, if you want to make an application to the IRS for an individual determination letter regarding the qualified status of your own plan, that application has to be submitted to the IRS by that same deadline, by July 31st of 2022. Keep in mind, this does not apply to defined benefit plans. So, that was last year. It also does not apply to what we call individually designed plans. So if you don't use a pre-approved specimen plan, you don't have to worry about this deadline. But if you're using a pre-approved specimen plan, make sure you're talking with your provider to determine where in the process they are. because you'll need to make sure that that's taken care of no later than July 31st of 2022. So that's it, Adam. I'll turn it back over to you.
Aaron, thank you so much. Anytime we have anyone from your group on the webinar, I'm very grateful that you're part of the firm, because I don't understand anything that you talked about, but that's why you're here. So thanks so much. Okay, one thing I wanted to address before we move to our next topic. We've had a number of questions about the HERO Act designation. You're all very correct in pointing out that the HERO Act designation expires on March 17th. The state is going to be reviewing it. We will keep an eye out for you all and certainly update you on our blog and on the webinar next week with what the state decided to do. Okay, next up is Travis Tallarico. Travis has been on a number of times. He's in our Rochester office, and he's going to talk about a recent decision from the New York Court of Appeals.
Thanks, Adam, and hello, everyone. As Adam said, I'm going to be taking a few minutes this afternoon to walk us through a recent and quite significant decision from the Court of Appeals that has some fairly serious implications for corporate lenders and corporate borrowers. So if we can go on to the first slide, please. So starting with, rather than starting with the details of the case, I'll give us the answer off the start. So the Court of Appeals was posed a question by the Federal Second Circuit in New York State, is if the interest charged on a loan is determined to be criminally usurious under the applicable penal law, is the underlying contract void in its entirety? And the answer to that question is yes. Now I'll be walking us through a brief summary of the case and the court's reasoning behind such. So the case at hand is Adder Bays versus Gensys. In that case, the plaintiff Adder Bays issued the defendant Gensys a loan for $35,000 with an 8% interest rate that was set to mature in a year. Also significantly, and I'll explain why this is significant, the loan agreement contained an option for the plaintiff to convert either some or all of the debt into shares of the defendant's stock at a discount of 35% from the lowest trading price of the defendant's stock. This 35% is going to be significant because on the next slide, I'll explain why that implicates the criminal usury statute. So about 6 months after the loan was issued, the plaintiff exercised its right to request conversion of part of that debt. The defendant refused. The plaintiff sued the defendant for a breach of contract, and the defendant, Gensys, moved to dismiss, claiming that the contract was void because the rate of interest, including the conversion option, exceeded the criminal usury rate in New York State of 25%. Now, why I was explaining why that 35% on the prior slide was significant is because another question that was posed to the court in this case is whether a stock conversion option that permits a lender at its sole discretion to convert an outstanding balance of stock at a fixed discount, and whether if that should be treated as for the purpose of determining the violation of the criminal usury law, which the court did answer in the affirmative. So effectively, that 35% discount rate brought the loan within the purview of the criminal usury statute. Next slide, please. So in reaching its conclusion, the Court of Appeals reviewed the applicable law and provided what I think is a helpful summary for everybody for some of the usury laws in New York State, particularly that loans of less than $250,000 that are issued to individuals cannot exceed a 16% annual interest rate, otherwise known as the civil usury rate. Loans between $250,000 and $2.5 million cannot exceed 25% interest rate, the criminal usury rate. And the court also held that loans with a value of $2.5 million or more are not subject to the New York State usury laws. And so the court made a pretty important distinction here in coming to its conclusion. So it held that while the defense of civil usury is not usually available to corporations, a corporate borrower can still raise the defense of criminal usury in a civil action, so loans that exceed that 25% amount. So again, to be clear, this was a major part of the holding of the case, is that even though technically as it's written, the relevant section of the general obligations law disallows corporations from raising the defense of usury, that only applies to those of with interest rates of less than 25%. So, and also in part of referring to the general legislative history of the development of the criminal usury law, the court came to its final conclusion that loans that charge an interest rate exceeding 25% will be voided in their entirety, because it would, in essence, negate the purpose of the usury law to allow a lender to recover for loans or payments for a loan that it otherwise could be prosecuted for criminal usury. And the final conclusion is that it is a complete invalidation of the instrument and the contract in its entirety. So as we can see from this, some very important implications, obviously, for all lenders to be very aware of the way that they are structuring their interest rates for their loans, but also a very important decision for all corporate entities and all corporate borrowers to be aware of when they are getting involved with any sort of lending transaction.
All right, well, thank you, Travis. That was very helpful. Okay, last but certainly not least, backed by popular demand, we have Jeff Keel and Lou DiLorenzo, the two individuals who wrote the New York labor law book that we talked about last time. They are going to discuss some additional topics for you. So Lou and Jeff, the floor is yours.
Okay, good afternoon, everybody, and thanks for coming. If you remember 2 weeks ago, we talked about employer inquiries during the hiring process about arrest records, which you can't do at all for prior arrests, and criminal convictions, which is subject to a bunch of rules which we discussed. We had some very generous feedback after that session from the audience and a couple of questions. There was one great question: what about doing background checks on potential hires? So before we get to today's mailbag, I'm going to try to touch on that briefly. I say briefly because, of course, the answer is unnecessarily complicated. But there are three sources of restrictions on background checks. There is federal law, there's state law, and of course, there's New York City law. And when you think about it, background checks really come in one of two flavors: criminal background checks and credit background checks. I'm not going to talk about educational background checks or Googling employees. You'll find that in the book, but we don't have time for it today. As we discussed last time, to be on the safe side, you really don't want to know about or be inquiring about past convictions until you're at the point of making a conditional offer of employment to a job applicants. And the reason for that is, if you have the knowledge of a conviction and you don't give the job, there's going to be an argument that it is presumed that you didn't make the offer because you knew about the conviction. So best not to know. Under federal law, which is the Federal Fair Credit Reporting Act, what are called consumer credit reporting agencies, in other words, the commercial entities you would go to get a background check from, are limited in what they can report. And it is basically age limits on economic information, bankruptcies, judgments, and stuff like that. And the good news is, those limits do not apply if you are hiring for a position which pays more than $75,000 a year. Essentially, what you want to do here is make sure, if you're doing a credit background check, you want to use an agency which is familiar and guarantees to you that they will comply with federal law. And also, since it's subject to state law, New York state law. The New York Fair Credit Reporting Act also limits older economic information, but it also says that the inquiry cannot disclose information about race, religion, color, national origin, convictions that are more than 7 years old, information on alcohol or drug addiction, which is more than 7 years old, and information about confinements in mental institutions. So again, you want to make sure that you're using an agency which is compliant with that. And also, I would suggest that if you're going to get a criminal background check, you probably don't want to look at any of this stuff or even request it until you've made a conditional offer of employment. Fine, that one, by the way, there is an exception. It does not apply if the position pays more than $25,000 a year. New York City, of course, has its own law. It's called the New York City Stop Credit Discrimination in Employment Act. And unlike the federal and state laws, this one applies directly to employers who employ more than 4 people. Basically says in New York City, a covered employer cannot request consumer credit history at all, unless it's for a police or peace officer position, an applicant for a position in which someone's going to have disbursement authority of more than $10,000 or as otherwise required by law. Now, this only touches it briefly. This is technical stuff. This actually is, along with lots of other things, in Chapter 1 of New York Employment Law, the Essential Guide, which is called the hiring process. You can get that on Amazon. If you're a member of the New York State Bar Association, you can get it through the Bar Association, and I'm told you can also, through a tortuous process, try to order it through them if you're not a member. I want to assure you, the firm did not get anything for writing this book, and we don't get any royalties for selling copies. But having said that, if any one of you will go and buy 100 copies, Lou and I will come to your backyard and we will cook bratwurst and beer for everybody on your street as a reward for buying them. Now, let me move on to the mailbag from this past week. As it happens, Lou and I were in our London office at 221B Baker Street on a foggy night when Hudson, our administrative assistant, brought in a tray with a letter on it. And I opened that letter, and that was how Lou began the case, which I call the case of the employee from hell. Marge from Manhattan writes to us, I'm the HR manager for an advertising agency in Manhattan. We have a junior account executive who is the most challenging employee I have ever met. He complains about everything. He barrages me with emails complaining about his workspace, his supervisor, our support staff. He's constantly threatening to file discrimination complaints if we don't do exactly what he wants. In 2019, he filed 2 complaints with the New York State Division of Human Rights. The first one said we hadn't accommodated his chemical sensitivities. The second one said he was being paid less than female account executives at his level. We spent a fortune defending those. We got both of them dismissed with no probable cause determinations. And now he's filed a discrimination complaint with the United States EEOC, in which he claims he's a victim of national origin discrimination because his family came to America on the Mayflower. The EEOC invited us to mediate the claim, and we agreed. And we signed the mediation agreement, as did the employee, which says that the mediation and any statements or proposals made in it are confidential. Well, we were so frustrated with this guy, we made him a cash settlement offer. He didn't accept it. The mediation failed. And now he has told everybody in our office that we offered him money and how much we offered. And he's put that up on his Facebook and Instagram accounts, which are open to the public. I'm at my wit's end. My CEO is practically apoplectic. What can we do? Lou, I'm going to throw this one at you. What can the employer do to get even with this impossible employee?
Thanks, Jeff. I've spent a lot of time defending retaliation cases, as other people have in the firm. I've had several jury trials, and I write a major paper for the Practicing Law Institute each year on retaliation. In the last few years, the number of retaliation complaints have actually exceeded, for the first time, all other categories of discrimination complaints filed with the EEOC. It's a very popular form of claim discrimination. One of the reasons, I think, is it's fairly easy to prove. The employee has to prove that they've engaged in protected activity, they've suffered some adverse consequences, and there's a nexus between the two things. One was caused by the other. Under federal law, the standard of proof is the plaintiff must prove that the adverse consequences suffered are the but-for cause of the retaliation. In other words, I suffered adverse consequences because I engaged in the protected activity. All other forms of discrimination are pretty much, you only have to prove that the protected activity was a contributing factor to the motivation to cause the adverse employment action. I'm going to preface some of these remarks by the fact that we only got 4 minutes left, right? Adam, we'll try to stay on 12:45.
Yeah, that's right. But you got 8 minutes.
I got 8 minutes. Okay. We might make it. If we don't, we'll just continue this because this is kind of a law exam question, that the one that that Marge from Manhattan has sent in. So when we look at this issue of, so why are they difficult cases? They're very difficult cases to defend because the average person believes in retaliation. Our Judeo-Christian culture is based, has a basis of a tenet of retaliation. You look at the Bible, stripe for a stripe, eye for an eye. Every aspect, our literature, our movies. I think that Michael Dukakis, one of the things that killed him in his run for the presidency was he released a gentleman, I can't remember, Jeff probably remembers his name because he's our trivia expert. He released a guy out on parole. On the weekend, the guy raped and killed a woman. He was asked at a press conference, Dukakis was asked at a press conference while he was running for president, what would he have done if that guy raped and killed his wife? Because Dukakis was a proponent of getting rid of the death penalty. And the reporter asked, would you want the death penalty if the guy had raped and killed your wife? And Dukakis stuttered and hesitated and never answered the question directly. And America turned against him because we expect our president to retaliate. If somebody does something bad to us, bombs us, attacks us, we expect retaliation. We expect revenge. So does a jury. When a jury hears that somebody filed a false claim against a company, and the plaintiff is arguing, I was retaliated against for filing that claim, the jury says to themselves, well, you know, that's kind of human nature. We do retaliate against people when we believe they've harmed us for no good reason. And the more frivolous we argue the complaint is, the more possibly likely it is there was retaliation because we're angry that somebody did this to us when it was unjustified. So it's a very easy. It's easier than trying to convince somebody, an employer engages in sex discrimination or race discrimination. Retaliation is a much easier sell because it's a tenet of human nature. We're hardwired, believe it or not. So now, in this case, as other cases, one of the issues that comes into play is temporal proximity. How soon after the person engaged in the protected activity did the adverse employment action come? If somebody files an EOC charge on Friday and Monday we terminate them for absenteeism, there's going to be a high probability that temporal proximity, you're going to lose on summary judgment, no matter what you say, almost what you say, because the temporal proximity of those two events is so close. It looks like one was caused by the other, or at least a jury could infer that. There's a chapter of the Godfather book that Mario Puzo wrote that's entitled, it's a revenge chapter, and it's entitled Revenge is a Dish Best Eaten Cold. That maxim actually applies in the area of retaliation. The longer the distance between the protected activity and the alleged adverse employment action, the more likely you are to break the tie between the two. Most of the cases look at a 6-month period as being a reasonable time to think if somebody puts up with this for 6 months, it's unlikely that that was the cause of their action. The other lesson that we learn in this process is when it's time to discipline somebody, you need to engage in the discipline. If I had a nickel for every time somebody called me and said, I want to fire this guy, and I say, well, what's happened? And they tell me, and I said, is anything else going on in the life of this employee at your workplace? And they say, well, you know, last week we did hear that he was trying to start a union. Or last week he did make a claim to the health department about some irregularity in our process. Or he called the tax department. Or he threatened to call the tax department. I say to them, you know, it's a difficult time now to discipline this person because it appears that it's following on this protected activity. And then if I had another nickel for every time they tell me, well, he's a terrible employee. A year ago, we caught him stealing and we gave him a break and let him keep working. And 6 months later, He went into rehab. He was an alcoholic. He was caught drunk at work, and we didn't fire him. And they say, so all those things happened, so that should justify me firing him now, right? And I say, no, that's actually worse for us, because he engaged in all these dischargeable offenses. We did nothing about it. Instead, we sat on it. But once he tried to start a union, we decided, you know what, now we got to fire him. It's actually going to make his retaliation case. The other thing you have to keep in mind in these cases is that they often accompany a retaliation claim goes hand in hand with an underlying discrimination or protected activity complaint. I'm being discriminated against because I've been sexually harassed. And by the way, once I reported it to my supervisor, I started being retaliated against. So it's usually hand in hand. The mistake that often gets made is people investigate the sexual harassment case, decide that there's no merit to it, and then engage in adverse action against the employee. You don't need to have an underlying discrimination complaint to provide the protected characteristic to the employee. Making the complaint protects them. Now, there's two types of retaliation cases. One is what we call opposition retaliation, where, such as this one at the end, where he's on Facebook claiming he's been discriminated against, other people have been discriminated against. That's opposing discrimination. That kind of a complaint, there is an obligation under the law that the employee have a reasonable good faith belief that discrimination has occurred. Kind of common sense, what we would expect, right? That an employee can't just make this up or be lying about it and still be protected. However, the other type of retaliation is that if you engage in participation retaliation, somebody has participated in a process under the EOC, for example, or your internal complaint mechanism, or filed a charge with the Division of Human Rights, that person is engaged in what we call protected participation activity. He's participating in the process. That person does not need a good faith belief. That person could be lying and they're still protected. The reason is the EOC and the agencies want to protect the system so that people are not discouraged from using those systems. So it's an absolute protection. Somebody lies to the EOC, you can't fire him for it. Somebody lies under oath testifying in a proceeding that's supervised by the EOC or the Human Rights Division or the City Commission, you can't take action. They are bulletproof based on their participation. So we have to be careful. We have to be careful in those differences. Now, the example that Jeff has given us, ending with the idea that this guy has breached his obligations under the EOC, it's almost a reverse participation argument. In this case, depending on how risk tolerant the organization is, there could be a basis for firing this guy. Now, we deal a great deal in our book on the use of social media and what kind of protection you have. And there's a great deal of protection. This is an out-of-work activity. Labor Law 201D, covered in the book, protects outside activities by employees that are lawful. This one, I would argue, is not lawful. He violated the EOC's procedures by breaching the confidentiality agreement we're all required to sign when we mediate before the EOC. And the reason for that is to provide kind of a cone of silence, if you will, over the mediation, so employers and employees are free to go to that mediation, you know, let their hair down, so to speak, coming from a bald man, let their hair down, say whatever they want to say, and it's confidential. It's not going to be used against either party. It's never going to leave that cone of silence. He breached that participation requirement, and the breaching of it discourages employers and others from using that process, something that the EOC should jealously guard. Now, here we might reach out to the EOC in advance, perhaps, and try to touch base with some of our friends there to say, look, this is what happened, and we hope you're as outraged as we are, and we'd like you to do something to them. Send them a letter or make some kind of a ruling or hold an inquiry or something. Give us maybe some protection from what we're likely to get when we fire the employee, if that's what the CEO and the HR department insist on doing. But it is a problem. But in addition to him breaching the EOC procedure, he's cloaked himself in the discrimination as well. So we want to try to create the best case we can to get out on summary judgment and not have a trial over the factual issue of whether one of the contributing factors to our actions under the New York City law or the State Division of Human Rights law was that he engaged in the protected activity, which would make it illegal. There's a great deal of confusion in jury trials when they're given those two different instructions. I think I'll stop there. Is this about the right time, Adam?
Well, Lou, let me add one thing. I think the takeaway from all of this is we have not given you a definitive answer, but when it comes to retaliation, there's a good chance that an employer is playing with fire. And I'd also like to point out, we are not just talking about retaliation for filing discrimination complaints. In addition to traditional discrimination complaints, in Chapter 11 of the book, I count 14 different New York State statutes which prohibit the retaliation, including the labor law, the civil service law, the not-for-profit corporation law, the social services law, the education law, and the workers' compensation law. So if you take anything away from this, the urge to get even means you have to take a really deep breath and get some advice before you go forward on doing what otherwise feels totally natural and appropriate.
Jeff, I think those are great remarks. I had a grandfather that used to tell me that revenge is great, but only for a short period of time. You got to be careful with it. And we got to avoid that instantaneous gratification and fight against it. I'd like to pick up, with Adam's permission, I'd like us to pick up this hypothetical next time we're on, and also deal with some of the proper steps before you discipline someone for anything, and deal with discipline and discharge along with this concept of retaliation. And I'm not going to be resentful about the fact that it seems the Italian guy is always given the retaliation topic to deal with. I don't think that's intentional by Adam or anyone else, or you, Jeff. And I would add that if somebody buys 100 copies, I'll throw on my immigrant parents' recipe for tripe, which is just delicious. We could do a great barbecue with some tripe.
There go the sales.
Lou and Jeff, thank you so much. That sounds great. And we look forward to having you back on in a couple of weeks. If anyone has any questions, feel free to reach out to any of the panelists today. Thank you for joining us, and we'll see you next week.
Thanks.
Thank you.